Afternoon, please be seated. Welcome to the First Court of Appeals. We have one case on the docket this afternoon. It is number 01-20-00169 Azhar v. Sarari. Will counsel please make their announcement?
Alan Daughtry here on behalf of appellant. I think we have a total of 15 minutes. If I could then reserve 3 minutes on the...
Well, I was going to get to that in a second, so we'll let your announcement, sir.
Good afternoon, Greg Costa for the appellee, also with Jeff Joyce at Take Counsel today.
Thank you, counsel. Each side will have 20 minutes for argument. If you wish to reserve any for rebuttal.
Yes, 5 out of the 20.
Okay.
I just remember Murray Cohen's first argument off the bench. He didn't reserve it, and that was very...
Right.
That's why I tried to jump the gun.
I appreciate that. Thank you, counsel. So very good. Before we begin, let me state that we don't need a recitation of the facts. We've read the briefs, we're familiar with those. Be most helpful to us if you can just dive right into the legal issues. So with that said, we're ready to hear for counsel for appellant.
May it please the court. I am going to address a lot of the post-divorce partition issues because there were questions asked, but I do want to at least have a mention of ASHPAC in the beginning. To reverse the judgment here, this court does not have to reverse its prior precedent of ASHPAC. It's different. There, the wife admitted that she had notice prior to having the divorce certificate issued. Didn't happen here. In fact, one of the controlling things was the arbitration council, the administrative body that actually did the divorce, pronounces divorce. It answered in sworn denials that there had been no service on the wife. They instead did publication notice in a local circular 4 to 5 days before the actual divorce. Bada bing, bada boom, 5 days notice, which she didn't get. She's divorced. That's not due process.
So, assuming, given all those facts, how do you deal with or respond to the issues that case was still litigated all the way to the Pakistani Supreme Court, and your client participated in that litigation? So even if we were to say that there was a lack of due process and notice, there was participation thereafter, and I'd like to hear what you
Sure,
say.
and I want to address it, prepared to. First of all, having appellate review does not cure or somehow anesthetize prior lack of due process in the initial proceeding. But if you look at the subsequent appellate proceedings, and they were appellate, they show a lack of jurisdiction on those appellate proceedings, not in front of a court that could actually have jurisdiction to do something. Tab 1 in their brief, these opinions are cited in the record like probably 50 times, but that's an easy place to find them. The Supreme Court order, tab 1 in their brief, paragraph 2, it says, these were foregoing contentions or questions of fact that cannot be answered, resolved without recording of evidence. This is a constitutional jurisdiction. So they said you can't do it here. So it didn't have some stamp of approval like it was done. It said you didn't do it in a manner, your appeal did not do it in a manner where they had jurisdiction to deal with that. And
So the appeal didn't, so there was no jurisdiction over...
The process that was initiated, and I'll tell you, and when I get to the second opinion, it says go to the family court. But first, so it says you can't do it. And again, just like mandamus jurisdiction, this court cannot consider contested facts on mandamus. And likewise on appeal, the court cannot take new facts or resolve or determine facts on evidence. Unless, there's mootness, but that's not really what we're talking about. Then the second opinion, tab 2 in their brief, goes on and on and on about, hey, you went about it the wrong way, and your relief is in family court. Tab 2 is the Lahore appellate opinion. Paragraph 4 talks about, we're sitting here in appellate constitutional jurisdiction. We can't deal with disputed issues of fact. They cannot be determined here. Paragraph 7, they also note that the certificate was served only through notice of publication 5 days before it was deemed to be an effective divorce. Paragraph 10, it says that the family courts would have been proper jurisdiction. Paragraph 11, but it says, hey, but we're a constitutional court, and all these proceedings that are going on are constitutional court issues. Like a mandamus, you cannot get into disputed issues of fact. Then paragraph 13, this is a kicker. It says, we observe that respondent number 1, here Azhar, may seek a remedy before the family court in terms of the order dated 15/01/2016, which references back to paragraph 9, saying you can raise those issues in front of the family court. She never did. So what their argument is,
So why didn't she?
I don't know, and I don't think, and frankly, I think there would have not been any rights or relief there. They cannot do property divisions. And they don't do them here, and they don't recognize any marital property rights in Pakistan that flow here in Texas from her residing here.
But wasn't there an expert who testified the opposite, that there is?
There's an expert that
And may I please just make sure that it's not just semantics. I think it's important for us to distinguish between what we consider property division and what would otherwise be property awards. And so isn't it true that there was an expert who testified that through the divorce certificate there was an award of property inherent in the order, because the law provides that whatever is the husband's is the husband's and whatever is the wife's is the wife's. And so again, even though it wasn't explicitly provided in the divorce certificate, that there necessarily was an award of property there.
No, I disagree on that. I don't think that's also, I think it's undisputed that there is no property division based upon a certificate. And a certificate's done by an arbitration council. Cannot do anything but actually grant the status of divorce. No adjudications whatsoever. You can have contractual views about whether a wife can get a divorce or not, whether a wife gets certain property or property rights or not, but the arbitration council doesn't do that, and that didn't do it. And moreover, a claim has been raised in other cases that the divorce certificate is based upon a marital agreement called a nikahnaमा, which is not a premarital prenuptial agreement that would be recognized anywhere in the United States as saying you don't get any community property rights. It's not.
So let me just ask a quick question just to make sure I understand. So if I understand correctly, the due process issue and the petition of property, neither of those are included in or subsumed by the judgments in Pakistan?
Absolutely. Not addressed whatsoever. They all say you didn't have jurisdiction to do it this way. Go to the family courts.
In Pakistan?
In Pakistan.
Okay, and again, so then the question from Justice Guerra was, what happened then?
What happened then?
Did they go?
No, there were no follow-up proceedings in Pakistan. She got back to the State Department. Another distinguishing factor in Ashfaq is that there was reliance based upon the marital status determined by the State Department. There, the State Department had determined that the wife Ashfaq was deemed divorced. Opposite here. Here, it got back through the State Department as a married woman on a spousal abuse visa. And so that's a distinguishing factor. Moreover, some of the property issues on due process were not considered by the Ashfaq court because the court did a Chapter 9 post-partition division. And also, again, recognizing that that hadn't been done. It's the same certificate of divorce process. And then, of course, the court allowed in Ashfaq and affirmed a property division post-divorce because nothing had been adjudicated. And there's no premarital agreement here, and that wasn't raised. And the other interesting fact about all this is here there was an admission, and if you look in the findings, it's their omitted claims. There was no adjudication. It's waived based upon non-suit without leave to refile. Okay, well, that reflects a profound misunderstanding of post-partition claims in a family law context. Res judicata is part of it, but there is no merger and bar, woulda, coulda, shoulda type of preclusive effect. The point is, in fact, Brown versus Brown out of this court, 236 Southwest 3rd, 343, and I'll give a follow-up letter, talks about the test for post-divorce partition. Res judicata bars post-divorce property division actions only when the divorce decree has disposed of an asset at issue. There is nothing that's been disposed of here. So this type of merger and bar, woulda, coulda, shoulda doesn't work in a partition context, whether it's under the property code or Chapter 9. And there was nothing done here. But again...
Okay, I'll let you go first.
So let me shift to the Chapter 23 partition. So how do you respond to Appellee's supplemental briefing that you didn't raise the Chapter 23 claim in the appellate briefing here with us?
I raised the fact that I made a complaint that there had been no post-divorce partition. And those claims were in our petition, and they were not addressed. So the complaint was that the court allowed this to go with denial of those rights. whether they're under Chapter 23, whether they're under Chapter 9. He did not do a just and right division. And that affects everything. Because in Texas, status of marriage and division, those go hand in hand. You cannot have an adjudication of whether you're married or not without a property division. And that's never happened. So
those are detached in Pakistan. Those don't.
No, they're totally relevant, because the divorce, again, when you think about, can you have a merger and bar from a court proceeding that doesn't have jurisdiction? Well, the actual determination, the actual res judicata would have been from an administrative certificate, which just goes and says, you filed it, I'll send notice. After 90 days, if the husband does not choose to reconcile, you're divorced. That's all it does. It's a registration process. That was the divorce decision. It cannot and will not do anything else but that. So those claims could not have been raised in front of this administrative arbitration council. That's just not how it works.
Let me just circle back around. So then, going back to the validity of the divorce in Pakistan and the omitted asset claims, did you challenge, in finding of fact number 11 and other conclusions of law, did you challenge, are those challenged on appeal?
Yes. In fact, the whole point about talking about due process, that there was not due process, that there was not an adjudication of rights, that this wasn't fair and that she didn't get notice, that's that's repeated over and over and over again where we dispute that.
But in terms of the specific finding of fact, was
I don't know that I specifically mentioned that. I think I said it, and then I said that's wrong. And in fact, if you look at it from, on facts regarding, I think that one is on due process. When you look at specific facts, I can't believe when people cite City of Keller versus Wilson, but I think the arbitration council's own determination, the administrative body, that they didn't serve her, that they just published notice 5 days before she was deemed divorced, that's controlling. That would be a type of controlling fact that he would be bound by. But it was clear that there had not been notice given. And we dispute that from a due process standpoint. And again, the whole absence of property issues is another significant due process concern that was never addressed in Ashback because there was a post-partition division. But again, that was the complaint. One way or the other, she has to have some rights for being married in Texas. You had a divorce proceeding or a proceeding filed here, Texas law controls 1.103 statute. And moreover, 7.002 is a choice of law type provision that does away with where assets located and says you have community property rights, regardless where they are. Ironically, the husband, Ali Chowdhury, hadn't lived in Pakistan since he was 3. He was here and has significant assets and holdings. And just to sort of clarify the degree of harm here for the lack of a property division, there was evidence provided multiple times in the record that if you just look at his financial statements filed right before the divorce with banks for loans and right after the divorce certificate, his worth increased by $100 million with new properties, new holdings, and what have you. So this is not like, we're dealing with some small change or something. This woman had significant community property rights. And also, that's a public policy here.
Let me ask you, so what, and I may have missed your argument about the finding of fact, but what is your argument about why the validity of finding of fact number 11?
If you could just, is 11 the one on due process?
Yes, sir.
Sure.
Well, it's finding of fact finds that the Azhar filed claims in the courts of Pakistan that had jurisdiction to consider her admitted claims. Azhar did not pursue her admitted asset claims in the Pakistan courts, although she had the right to do so, and although the Pakistan courts had jurisdiction to consider those claims, Azhar's claims in the Pakistan courts contested the validity of the Pakistan divorce, and those claims were rejected by the courts of Pakistan, ultimately affirmed by the Pakistan Supreme Court. So those are the
Let me break those down.
So those are findings of fact that we
break those down. She did not raise those. They were not considered. They were not adjudicated. The finding actually confirms those are omitted claims, things that were not done. And partition claims, we don't have omission. The appellate proceedings that are referenced in that finding that the court relied upon only determined that there was no jurisdiction for that type of thing here in those courts. Not a single of the appellate decisions, including the Supreme Court, indicated that
But the finding said is they did have jurisdiction.
the Pakistani courts could have had jurisdiction. There was an expert testimony that a court, the family court, could have adjudicated this, but all of the decisions from these courts that are attached, relied upon, and incorporated, and said, we don't have jurisdiction in this capacity to consider, as a constitutional court, disputed facts. Those have to go in the first instance, and they keep on saying, go to the family court. She didn't do it, but the clear finding there is that these are omitted claims. They weren't done, they weren't adjudicated. Could she have done it in Pakistan in a family court? Although I disagree with expert Mohammed Sheikh, or actually I think it's maybe Sheikh Mohammed, but that Pakistan might afford community property recognition and divide assets, even though there was conflicting testimony with two other experts, one of whom was Ali Chowdhury. It's clear, though, these were omitted. This was not done, and it was not adjudicated by this court, by these courts. The appellate courts, the appellate decisions, the only ones that she pursued, said we don't have jurisdiction or power to adjudicate these facts.
So I believe that in the judgment, well, in the findings of fact and conclusions of law, that omitted claims was a defined term. It wasn't a term that was, how can I explain it? It was a defined term that was defined in terms of what would otherwise be a Chapter 23 claim, right? So it's, and it's used in capital letters. I think it's using that defined term, and so I want to make sure that we're using that language correctly. I don't think that what was stated as an omitted term and defined in the findings of fact and conclusions of law is necessarily what we would otherwise be talking about as an omitted claim.
But
right?
It's clear that when the judge meant omitted claims, it meant the claims for some type of division of property, whether Chapter 9, 23, what have you. But the omitted claims were trying to get some type of adjudication or property division. By saying it's omitted, the omitted claims, they were not pursued. And the whole basis of the argument, the whole basis of the finding, they were omitted, they weren't pursued, and she non-suited, she didn't get that, she didn't pursue them, which is a woulda, coulda, shoulda, merger and bar type of bar, and the preclusive effect of that doesn't happen with a Chapter 9 claim or a Chapter 23 claim.
So if we were to say, yes, the Pakistani court did grant the divorce, there is a valid divorce certificate that has pronounced this couple divorced, then, and what I understand you to say is that the Chapter 23 claim would only apply to the extent that there was any award or division of property, and because there was none and it didn't touch on any division or award of property, then there would not be a Chapter 23 claim. Am I following you?
No, because there was not a just and right division of any marital property, any community property whatsoever. Therefore, the omitted claims, therefore it has not happened. There's no res judicata effect. From a Chapter 23 standpoint, she is a tenant at common, subject to partition under Chapter 23, and under Chapter 9, it should have been adjudicated and done a just and right division, which frankly is, actually going through. But to the extent that claims were not, where property was not awarded, adjudicated, not awarded as community property being divided.
And we'll let you wrap this point up because it's your time.
I'm sorry, I didn't see I went over. What it means is those are not barred and they can be pursued here, and they should have been pursued here.
Thank you, counsel. We appreciate it. Now time to hear from Appellee.
May it please the court. 3 deeply rooted legal principles require affirming here. First, international comity. Second, res judicata. And third, the deference that is owed fact-finding by a trial court. What the appellant is asking for today is unprecedented. They haven't cited a case, and I haven't seen one, where the person trying to avoid a foreign judgment is the one who initiated the very proceedings that are being given respect under common principles. And I'd like to start off by walking through what happened in Pakistan, because I think it wasn't quite clear from opposing counsel's presentation. There was a divorce in the arbitration council. Then the appellant decided, before she ever filed anything in Texas courts, which started in 2015, before that she filed a case in the civil court in Islamabad. challenging the divorce, and the expert testified that civil court allows you to seek property distribution. She then dismisses that case that has effect, it's a with prejudice dismissal. But then in 2015, she files again in a civil court, essentially a trial court in Rawalpindi. She files another case in 2016 in Rawalpindi that again is withdrawn in essentially a with prejudice dismissal. So it's at that point that it goes up to the appellate courts. The high court, the single bench, finds in her favor, which belies any notion that there was no due process here, that it was one-sided hearing. She actually won at one stage of the proceedings. And I have to say, the whole notion of being denied due process when you are bringing the case really just doesn't make much sense. Then it goes up to the double bench, and that court recognizes res judicata effect. Opposing counsel stated some parts of that opinion that do say, look, at this level of constitutional courts, we can't be the ones to engage in fact-finding. But the point is that the civil courts where she first pursued her challenge to the divorce are the place where she could have gotten property division. And this is what the double bench said, and this is in page 43 of our opening brief, and it's at page 6 of the double bench opinion. It says, it is manifestly clear from the above that the suit questioning the validity of the divorce certificate, that was the one she filed in civil court, was withdrawn without seeking formal permission of the court as is required under Order 23 of their civil rules. The respondent was thus precluded to bring any fresh suit proceedings to this effect in view of the bar contained in Order 23, Rule 1 and 3. So it's that second highest level court in Pakistan that finds that she was precluded even within Pakistan because she'd withdrawn the case with prejudice at the trial court level. And then the Supreme Court endorses that and says, yes, we in a short opinion, agrees with the ruling of the double bench and actually says this is a frivolous appeal being brought into the Pakistan Supreme Court. So if anything, this is a much, much stronger case for comedy than Ashfaq. In Ashfaq, all that happened was the divorce and the arbitration. It was initiated by the husband. The wife initiated no proceedings in Pakistan. Here you have what was given preclusive effect by Judge Woolridge was these opinions where she's challenging the divorce.
But that's a challenge to the divorce itself. And say we do take your point on the divorce and we decide that the parties are divorced. But here it seems like there's a difference between comedy with respect to an order that actually finds something and what I understand opposing counsel to be saying is a lack of an order, a lack of any disposition of property for us to deal with in that way.
Yes, Your Honor. So, first of all, the divorce in Pakistan, and I would direct the court to Mr. Sheikh, the expert's testimony. It's the August 23rd, 2019 transcript of page 121. And this is just consistent with what is recognized as the rule in Pakistan, is that absent of change in the marriage contract, property stays in the name of the person who holds that property. So that's what happens in the arbitration council. But then there was expert testimony that in these civil courts, she could have brought claims saying that I still should have rights to some of this property. I mean, that's the testimony Judge Woolridge credited, and that I don't even see the other side challenging the factual finding on that. I would point to 11A of the factual findings. Azhar filed claims in the courts of Pakistan that had the jurisdiction to consider her admitted asset claims. B, she decided not to pursue those, but then that has res judicata effect. If this court were not to recognize that res judicata effect, you're basically giving the appellant 2 bites at the apple. She can go through the Pakistani courts, and if she wins there, she's certainly going to want that decision to be recognized here in Texas. If she did win again at the single bench, I'm sure she was going to say that that decision should have been recognized if it stuck. So allowing her to go all the way through the Pakistan court system, lose, and then try to challenge it here gives her 2 bites at the apple. That's
Is that an impermissible collateral attack on the Pakistan decision?
I'm sorry.
Is that in essence an impermissible collateral attack? Is that what you're...
Exactly.
The essence of your argument?
Exactly, and that's what res judicata says, is you get one chance, you don't get multiple chances, there has to be some finality to these decisions.
Could I ask you about the 2 bites at the apple? This is a very complex case. It's fascinating. I've really enjoyed the briefing from everybody involved. But one question that I have is it 2 bites at the apple? Because what I understand the appellant to be saying is that she hasn't gotten a bite at the apple yet, that she didn't go through those processes in Pakistan, and instead she's trying to get that first award of property here. So if she hasn't had a bite of the apple yet, then how does res judicata play into that?
Right. Well, Pakistan, which is just like the United States, a former British colony, so its law has roots in British common law. It recognizes that really the most important part of res judicata is not just there's preclusive effects on the claims you bring, it's that there's preclusive effects on any claims you could have brought, right? So she challenged the divorce in these civil courts where there's expert testimony the district court credited saying those courts have the jurisdiction to consider how to deal with the assets. And she could have even argued to apply Texas community property. There's testimony to that effect that is, again, credited by the trial judge. And so that was her bite at the apple. She kept pursuing these claims all the way up to the top of the Pakistani court system. I went through that list. I think it's 5 cases she initiated. And those proceedings in civil court, not in family court in Pakistan, the unchallenged expert testimony is that you can pursue the property claims. So I agree, Judge Woolridge found she didn't actually pursue the property claims in those civil court proceedings in Pakistan, but res judicata, it's the test we all learned about if it arises out of the same transaction, it's preclusive effect. I mean, take this out of the family law context. Let's say she filed in Pakistan a commercial dispute someone files in Pakistan or Britain or France that says breach of contract, and they lose. They can't then come to the United States and pursue the same claim saying it's a breach of fiduciary duty, right? Res judicata would say if it's the same dispute, if it's the same transaction, you're precluded whether you brought the claim or not, and that's exactly what Judge Woolridge found in 11F. Pakistan's law of res judicata and its corollary rule bars claim splitting. A party may not pursue some claims arising out of a transaction and then later bring other claims arising out of the same transaction. And that's Pakistan's law. It's under comity principles, it should be respected, but it also happens to be our law.
So, and this is not the case here, but just kind of got me thinking, if there is property that's community property that's titled in both the husband and wife's name,
Right.
and the way I understand Pakistani laws, to his, to her, hers, or to him, his. If there is community property officially titled in both of their names, then they're under that divorce decree, then wouldn't they be what we would say as a Chapter 23 claim, kind of tenants in common, such that there would necessarily have to be some division or award of property in that case? Does that make sense what I just...
I agree that would be the default rule. It stays in the name of the property holder. So if a bank account, for example, were jointly in both of their names, I would agree, Your Honor, with your point.
So then that would mean that we would be in the realm of a Chapter 23 claim where there would have been some award under this divorce certificate of property, but there's basically sort of outstanding property titled in both of their names that was not actually really handled in that divorce certificate. Am I sort of articulating that the right way?
If the title was held in both of their names, that makes sense to me, Your Honor. I do think most of the property here is held actually in corporate or business entity names, but I would agree with your view on that.
Let me ask you a quick question, counsel. So what weight do we need to give the findings of fact, particularly finding of fact 11 in this case?
I think they control the case. I mean, for one thing, I don't see the brief of the appellant as challenging those factual findings. And so to me, that they've forfeited or waived their right to challenge those factual findings. So it should be dispositive on that ground. But second of all, even if the court somehow thinks that was preserved, of course there's deference to fact finding. As long as there's any testimony in the record to support it, the trial judge was entitled to make credibility determinations. And so I think the testimony on that testimony from August 23rd from Mr. Sheikh, the Pakistani law expert, is certainly sufficient under any review, under any attack on the factual findings to support.
Was there any controverting expert testimony on that issue?
Not that I saw in the 2 days of hearing that Judge Woolridge held on this omitted asset point. And I would like to, Justice Guerra already pointed this out, but on Chapter 23, it is true, their brief focused on Chapter 9. And didn't raise Chapter 23. So I think, again, they forfeited the right to challenge any Chapter 23 ruling. But at the end of the day, I don't think that matters at all, because if you look at the district court's findings, paragraph 8, and I think this is what you were alluding to, it says, before the August 2019 order was signed, appellant amended her petition to assert, in the alternative, claims under Chapter 9 or Chapter 23, trying to contend the parties' jointly owned assets, and then it says, parentheses, these are the omitted asset claims. So the ruling itself below applies equally to both Chapter 9 and Chapter 23. The finding that there was res judicata would apply to either of those. And then the Texas Supreme Court's decision last year in SC, I think, makes that clear if there's any doubt, because Justice Young says 9 and 23 are just alternatives that are both seeking the same thing. Chapter 29 basically incorporates the community property standard, even though it's post-divorce, whereas Chapter 23 is this older equal division principle, but they have the same effect, and a party needs to elect one or the other. So there's really no basis for saying that Chapter 23 somehow survives when Chapter 9 doesn't. The ruling below applied to both, and under the Texas Supreme Court's decision, they're just two standards for doing the exact same thing.
So distilling everything down to the simplest possible place, if that's possible here, is it fair to say that the question of comedy, in your client's view, is focused on the decision of the Pakistani Supreme Court? The comedy issue is, as opposed to the divorce decree itself. That is, am I correctly summarizing that?
The only modification I would make, I think it's the trial court proceedings that were initiated by the appellant that go all the way up and culminate
Right.
in that Pakistan Supreme Court decision. Yes, that's what Judge Woolridge gave effect to. He decided to give respect under comedy principles. That, of course, is reviewed for abuse of discretion. So, even if the court thinks maybe that wasn't the best way to do it, as long as it wasn't an abuse of discretion. And in my view, Ashfaq, less than 10 years ago, this court upheld comedy recognition to a Pakistani divorce. For 3 reasons, this is actually a much stronger case for comedy. Number one, a big issue there was the appellant was domiciled, the wife was domiciled in Texas when the divorce happened. Here, the appellant had been back in Pakistan almost a year. She was domiciled back in Pakistan when the divorce happened. So you have a marriage. The marriage, of course, happened under Pakistani law. And then the wife's back in Pakistan when the divorce happened, so it seems to be the most logical place. And there's certainly no argument about domicile like there was in Ashfaq. Number 2, in Ashfaq, this court gave recognition to the ruling of just a council, essentially this tribal council. Here you have something that went all the way through the entire Pakistan court system. And it's hard to find comedy decisions that don't respect judgments of a country's highest court. I would think there could be repercussions of a court decision saying that Pakistan's Supreme Court doesn't provide due process or is in other ways not a fair court. And then the third distinction was one we've already talked about, which is that she initiated multiple cases in Pakistan. In Ashfaq, she was just on the receiving end of the divorce. The divorce was filed by the husband. Here, there's multiple court proceedings that the appellant brought in Pakistan. And again, I've seen no case where the person who brought proceedings can then say, well, I know I appealed to the Pakistan Supreme Court. I tried to get justice there, but we shouldn't respect their decision. Because again, it lets her get 2 chances at the apple. If she'd won there, she'd certainly be seeking recognition. So for those 3 reasons, I think this is a much better case for comedy than Ashfaq. But if anything, that it's controlled, I think, by that decision.
Let me just follow up with the question I asked your opposing counsel was that the issue of the division of property and that the due process considerations were not part of what happened in the Pakistani decisions from the Supreme Court. I know it worked its way up. Were not part of that decision and not reviewed by that court. What's your response to that?
Well, first of all, it's in the record that the Pakistan Supreme Court had the file from the Arbitration Council proceedings. Right. So they had the entire file from the Arbitration Council. And again, I think the critical point is what was the Pakistan Supreme Court looking at that had happened below in the court proceedings. And the principal reasoning was she had a chance in the civil district court. She brought this as an attempt to vacate the divorce. And she then withdrew that, and that had preclusive effect. And then certainly in those cases she initiated, again, it's hard. How can someone say they weren't denied process when they were the one? Due process is all about notice and an opportunity to be heard. She filed these cases, she certainly knew about them, and then she certainly had an opportunity to be heard at every single level of the Pakistan civil justice system.
I think,
No, after you.
I think you've already answered this with regard to res judicata, but just to get a little more pointed, how do you respond to counsel's argument that there was sort of an admonition that these claims should have been brought in the family court in Pakistan, and she didn't do that, and that the fact that she didn't, and again, I assume this is all subsumed within that res judicata argument, but how do you respond to that specifically?
Right. First of all, I read the court rulings differently. What they said is she first challenged the divorce in the civil court, first in Islamabad, then in Rawalpindi. The civil court had jurisdiction both to vacate the divorce and to consider property division, as I read both the rulings and, importantly, the testimony of the expert that the trial court judge credited. But she then twice withdrew her trial court filings, which had res judicata effect within Pakistan. There is in the double bench opinion, it does say at the end, you could also still try to go to the family court, but I don't think that in any way undermines the fact that what Judge Woolridge found, which is that she had the opportunity to present these claims in the cases she initiated in Pakistan and withdrew those cases which had res judicata effect.
But it's saying that, yes, you could do this in the family court.
Right.
Doesn't that sort of undermine the res judicata theory that would apply if that court thought that there was another viable option?
Right, but the civil court proceeding, first of all, which is the only one that would focus on the property issues, the Chapter 9, the Chapter 23, those issues, their idea of the testimony is that only the civil courts had jurisdiction over that. So as to the property issues, that was, there's an unchallenged testimony and evidence that those had to be done through the civil court. I think the fact that they said you could maybe still go to the family courts and get a different ruling there is something that she could have availed herself of but didn't. But I mean, the res judicata ruling really has to do with the property division. Because Judge Woolridge first says, I'm going to recognize the divorce, and then he says, as to these property claims, I find there's res judicata.
Which again goes back to the finding of facts, and so this is,
Right.
again, to try to distill things down to its simplest possible place. Does this basically boil down to an appeal regarding challenges to findings of fact and conclusions of law?
I would say that, I mean, as your honors have said, there's a lot of complexity in this case, it involves foreign law, but at the end of the day, I think it's no different than many of the appeals this court sees, in tort cases and contract cases, which is that what really is decisive is that factual findings were made here. Determinations of foreign law are factual findings. Justice Bland said that in Ashfack. And so it's like any other factual finding, and one, it wasn't even challenged here. Two, if you can get past that, it's well supported because the testimony of Mr. Sheikh on August 23rd extensively detailed the res judicata rules in Pakistan, which is what was credited by the district court.
So are you saying then that if she had gone back to the family court, the only thing she could have challenged in the family court was the fact of the divorce, or whether there was actually a divorce, and that the property award part of the judgment, is what I'll call it, would remain, even if she had...
Yes, that's my understanding.
Undoing the divorce wouldn't also undo any supposed award of property?
Well, if the divorce were undone, that might be right, but I guess the issue is whether these omitted asset claims, that those should have been pursued in the civil court. Assuming there's a divorce, you have to go in Pakistan to the civil district court to seek division of property, or to invoke Texas law and seek a community property division.
Right, so that's why I'm sort of pondering, okay, so if she had gone to the family court, nullified the divorce, then we would be back at square one? Is that... And I know this is outside of what actually happened, but
right.
I'm just...
I don't want to purport to be an expert on Pakistani law. I'm looking at the findings Judge Woolridge made, which I think were well supported. But I would also reiterate, the civil court, I mean, the courts recognized there that she filed there to undo the marriage as well. So the civil court also had jurisdiction over that, according to the record that I've reviewed. And again, especially the expert's testimony, Mr. Sheikh gets into that as well.
Do you have any more questions?
No.
Thank you, counsel. We appreciate your argument. Your time
All
is
right.
up.
Thank you, Your Honors.
Appellant's rebuttal argument.
All right, big distinction, trying to run through this. If you look through the high court opinion, first of all, the Supreme Court doesn't bless anything. It says we can't do it. It was frivolous because we can't do this. Nobody is blessed the validity, the notice, and yes, Chief Adams, it is a collateral attack when you deal with comedy. It's discretionary to give comedy to a decision, but it is an abuse of discretion when there's not due process. The fact that even if it had been approved, that Pakistan would allow a notice by publication on 5 days' notice for a status of divorce doesn't mean it complies with Texas due process. It doesn't. The finding of fact was she did not pursue those claims, and they were not pursued, and she did not get a property division. If you look at the effect of a divorce certificate in ASHFAC and in here, all it does is you are now divorced. That's it. That was the decision. She did not avail herself of that, as Judge Costa said. She tried to challenge it. The initiation of proceedings was the arbitration counsel, Ali, seeking divorce. He got a divorce. That was done. Then she got to challenge it. And if you go through the high court opinion, that's tab 2 in their brief, big distinctions. Paragraph 8 talks about how she'd had a claim and she withdrew it. That went to the validity. That's that they call that a bar because she didn't. They actually think a non-suit in Pakistan has preclusive effect under merger and bar. Then paragraph 9 of that talks about she had also done this other petition. That's the one Judge Costa talked about. Well, she did ask about property division there. That was withdrawn. When you look at the paragraph 13, referring to the paragraph 9 decision, before parting, we, however, observe that respondent number 1, Hira, may seek her remedy before the family court in terms of order dated 1501-216. That's paragraph 9, not paragraph 8, passed by the learned civil judge, first class roll Pindi, resulting into return of plaint for its presentation before the court concerned, if so advised. She could do it there. Do we have, I call it woulda, coulda, shoulda, have a divorce in Texas and they don't adjudicate property division of the house? Big glaring omission, okay? This is not, as Judge Costa said, take this out of the family law context. This is all about Texas family law. And an unaddressed house that should have, could have, would have been addressed in a divorce, should have been, but is not barred from getting adjudicated in a Chapter 9 claim or a Chapter 23 claim. The only thing, in Chapter, there are alternatives, but one is not preclusive of the other, meaning Chapter 23 goes on for unaddressed property rights when, based upon a 2-year statute of limitations after notice, that Chapter 9 remedies have not been used. With respect to the finding of fact, Chief Adams, the finding was she could have, she tried, she abandoned, she didn't, it didn't happen. There's no finding here that she had any property adjudicated. There would be nothing in this record. And there was competing testimony. But also, let's think about 2 different proceedings. You have the comedy proceeding. That was 3 days of live testimony heard by Judge Farr, not by Judge Woolridge. He heard not a bit of it. He heard no witnesses on that. Judge Farr found that it was a violation of due process and did not want to give comedy. That was the trial in front of the bench that Judge Farr heard. Then fast forward years later, without having any type of new evidence or any proceeding or opening up proceedings, Judge Woolridge just comes in and says, oh wait, no, I'm now going to give comedy. He didn't hear a single fact. He had a record that he didn't preside over. He didn't hear a witness and said he did it.
Was his ruling after the Pakistan Supreme Court decision come down? Is
Yes.
that the difference maker?
I think that would be, that was important in his mind. But he didn't hear any of the evidence regarding rights, remedies, what could be done, how it was done, notice that could be given. In fact, there's a big problem. You're not supposed to do notice by publication when you know the person's address. They knew, and it was all admitted, they knew where she was, but she never got served with notice. And that is significant here. That has not been disputed, that she didn't get notice.
Is there any testimony that more notice would have made a difference?
No, actually,
Look at that at all?
the problem with Pakistan is notice doesn't matter. I mean, it doesn't really matter. She doesn't have a say. You adjudicate the status. It's all the husband's determination. If the wife even wanted to reconcile and the husband didn't, 90 days goes by, boom, you're divorced. No say in it. And again, it's just a certificate of divorce. This was addressed in ASHFAC. That's all it does, doesn't do property. Moreover, when you get to the second big determination, property, there the court did have a record, but there was contested evidence. He allowed the comedy proceeding, which had testimony on that, to be brought forward and considered, and they had one live witness that had been an undisclosed expert opinion from Mohammed Sheikh, who was here for a limited time, came, he heard it. But Judge Woolridge's decisions were all based on the fact that property was not done, so therefore waived, and that's not how we do it in Texas.
Thank you, Counsel. Any more questions? Any more questions? And thank you very much for your arguments today. Thank you for your arguments and your briefing. With that, this case is submitted and this court is adjourned.
All right.